My HOA sued me because my house was blocking their view. The judge spent most of the trial trying not to laugh out loud. The gallery was already chuckling before the hearing officially began. The plaintiff's lawyer was holding up a childlike poster titled "Vista Rights of the People," featuring stick figure residents gazing tragically toward a crudely drawn house. The judge, stifling a grin, finally asked, "Counselor, under what legal statute does this artistic interpretation fall?" The HOA president, Diane, stepped forward to point at a map and accidentally indicated a sewage treatment plant 3 miles away. The judge had to take a sip of water to compose himself. "I'm Alex. I own a modest home at the edge of a development with an overly poetic name. I mind my own business." That piece ended when Diane, the association's chair, decided my residence obstructed the collective sightline to a scenic drainage basin, a glorified ditch. The absurdity arrived by certified mail. The third notice was particularly memorable. "Final demand: adjust your home's placement eastward by approximately 40 feet. She literally wanted me to move my entire structure. It intensified. Diane posted a view corridor protection chart in the clubhouse with dashed lines that went straight through my bedroom. She even sent a view assessment team with telescopic poles to take photos from my patio while I was away. Then I got the fine, $100 for non-compliant skyline interference. The citation read, "Owner has failed to preserve ambient sight angles from designated community vantage points." She was essentially billing me for the existence of my roof. The whisper campaign began. I was apparently a vista hog stealing sunsets. An elderly neighbor once asked me at the grocery store why I was so greedy with the afternoon light. Peak insanity arrived when Diane filed a lawsuit. She claimed my home created an obstruction beyond jurisdictional boundaries. Her attorney, a cousin whose office was in a laundromat, alleged I was infringing on communal scenic enjoyment. The discovery process was a treasure trove of madness. Their submitted evidence included a watercolor of how the neighborhood might feel without my home, featuring rainbows and unicorns. There was a photo of the Swiss Alps with a sticky note, "Aspirational view." My favorite was a satellite image where Diane had doodled a halo over the HOA pool and a frowning emoji over my lot. My lawyer, a man of few words and much paperwork, submitted the actual records, the original plot plans, my building permits, and the HOA's own charter. It proved the so-called Vista-protected view crossed land the association didn't own and never had. Their entire case was, legally speaking, in the wrong zip code. Trial day. Diane brought props. She attempted a live demonstration with a telescopic viewer sheet ordered online, claiming if you stood on a stool at dusk, my chimney disrupted the communal aura. The judge finally broke. "Madam," he said, leaning forward, "your covenants do not govern auras." My attorney stood. "Please show the court where these view rights are codified." Flustered, Diane cited Addendum 7. We all flipped through our binders. Addendum 7 was a lost dog flyer from 2004. Someone had scribbled "Bring pasta salad" in the margin. The judge laughed out loud this time. He dismissed the case with extreme prejudice, but he wasn't finished. He warned them about frivolous litigation and strongly suggested they'd be paying my legal costs. The HOA board, now terrified, convened. Their insurer refused coverage, citing an explicit policy exclusion for claims related to aesthetic disputes over skylines, weather, or perceived ambiance. The final judgment ordered $35,000 in fees. Diane was personally liable because she'd pushed the suit against the board's counsel. She was ousted by a unanimous vote and was symbolically reassigned to the Landscape Committee, tasked with cleaning the very ditch she'd called the Golden Basin. When the clerk handed her the order, she stood frozen, her mouth opening and closing silently, as if the concept of consequence itself was too large to swallow. Her briefcase and her arrogance seemed to deflate right there in the hallway. If you love a story where ridiculous entitlement meets the brick wall of reality, do us a favor, smash that like button, and for more tales of poetic justice, subscribe to Trending Tales Pulse. You can't sue a house for existing, but you can bankrupt yourself trying.